Hello and welcome to the Minimum Competence episode for Monday, August 11th, 2025. I'm your host for today, Andrew Leahy, a tax and technology attorney from New Jersey. On today's episode, we have Trump's FERC pick, a landmark National Guard trial, law firm Q2 gains amid risks, and the EPA ending its union contract. Let's remember, in summer, the song sings itself, and read today's legal news. On this day in legal history, August 11th, 1792, the United States Supreme Court issued its first reported decision in Georgia v. Brailsford. The case arose from the complex aftermath of the Revolutionary War when questions about debts owed to British creditors came before the new federal judiciary. The state of Georgia had enacted laws seizing debts owed to British subjects, while the 1783 Treaty of Paris required those debts to be honored. The dispute involved a British creditor, Samuel Brailsford, seeking repayment from a Georgia resident. Georgia argued that its confiscation laws extinguished the debt, but the court was faced with balancing state statutes against treaty obligations. In its decision, the court reaffirmed that treaties made under the authority of the United States were binding on the states even when they conflicted with local laws. This early opinion helped cement the principle of federal supremacy in foreign affairs and treaty enforcement. It also demonstrated the court's willingness to decide politically sensitive disputes involving state sovereignty. The ruling, authored before the modern opinion writing style developed, was short and straightforward, focusing narrowly on the facts and legal issue. It set an early precedent for judicial interpretation of the Constitution's Supremacy Clause. Georgia v. Brailsford thus marked the court's entry into shaping the balance between state power and federal authority. The case also foreshadowed the judiciary's role in resolving conflicts between domestic law and international agreements. While not as well known as later landmark cases, its legacy lies in establishing the court as a neutral arbiter in disputes implicating both constitutional structure and international commitments. President Trump is expected to nominate David Rosner, a Democrat currently serving on the Federal Energy Regulatory Commission, or FERC, as its next chair. The agency oversees decisions on natural gas export facilities and major power infrastructure, making it central to Trump's energy agenda. Rosner, appointed to FERC by President Joe Biden, previously worked for former Senator Joe Manchin, who was known for supporting coal and gas interests. White House officials say Rosner aligns with Trump's priorities despite his party affiliation. FERC was a flashpoint during Trump's first term when his appointees attempted but failed to push policies favoring fossil fuel power generation. Today, surging energy demand from data centers has renewed attention on expanding cheap power sources. In July, the country's largest electric grid saw record power auction revenues of $16.1 billion, highlighting the strain on supply. Rosner's promotion would follow the departure of Republican Mark Christie as chair, signaling a bipartisan leadership shift at the influential regulator. A closely watched trial began today in San Francisco over President Donald Trump's deployment of National Guard troops to assist immigration raids and manage protests in Los Angeles. California argues the move violates the Posse Comitatus Act of 1878, which limits the use of military in civilian law enforcement. The dispute centers on Trump's June order sending 700 Marines and 4,000 National Guard members to the city after mass immigration raids sparked unrest. State officials, including Governor Gavin Newsom, claim about 2,000 Guard members are still aiding U.S. Immigration and Customs Enforcement, or ICE, agents in raids and restricting civilian movement. The administration denies the troops engaged in law enforcement, saying they were protecting federal property and ICE personnel. The three-day non-jury trial before U.S. District Judge Charles Breyer could set limits on Trump's authority to deploy the military in U.S. cities. California is also seeking to regain control of its own National Guard from federal command. A ruling against the administration could have lasting implications for the president's power to use military forces domestically. U.S. law firms saw stronger than expected business in the second quarter of 2025, with overall demand rising 1.6% from the same period last year and billing rates climbing 7.4%, according to the Thomson Reuters Institute. Clients sought legal guidance on shifting tariffs, regulatory changes, and an unsteady economy, partly fueled by President Trump's trade policies. The growth was uneven. Top 100 firms experienced a 0.6% drop in demand, while the next largest 100 grew 2.6%, and mid-sized firms rose 3.5%, suggesting clients may be opting for lower cost or more specialized services. Practice area results also varied. Litigation demand rose 2%, corporate work 1.3%, M&A 0.3%, while intellectual property fell 1.4%. The industry's financial index score hit 55, up 4 points from quarter one, but the report warned of risks ahead as overhead costs climb, collections dip, and productivity lags 1.3% year over year. Unpaid bills and write-downs could create further financial pressure if trends persist. The U.S. Environmental Protection Agency has moved to terminate its labor contract with the union representing 8,000 of its employees, according to the union's president. The action is part of President Trump's broader push to limit collective bargaining rights across federal agencies. Trump's March executive order seeks to remove such rights at more than 30 agencies, including the EPA, and is being challenged in court by unions that argue it violates free speech and bargaining obligations. The EPA says it is acting in compliance with the order, which would make it easier for agencies to discipline or dismiss workers. The move comes as the EPA plans to reduce its workforce by at least 23% and close its scientific research office as part of broader federal downsizing. Unions, including the American Federation of Government Employees, are suing to stop the effort, but a recent federal appeals court decision allowed the administration to proceed with exempting some agencies from negotiating with unions. The union representing EPA employees has pledged a legal response. And with that, and as always, I thank you so much for listening to Minimum Competence, your daily news podcast for lawyers. If you're looking for more than Minimum Competence, links to further reading on all the topics touched on today are in the show notes. And reviews go a long way towards helping new listeners to find our show. If you have a moment, leave a rating or review on your podcast player. We'd sure appreciate it. And if you know someone that might be interested in the story we cover, consider sending them the episode. But remember, nothing here should be construed as legal advice because it is certainly never that. Minimum Competence is available at minimumcomp.com and wherever it is you get your finely crafted podcasts. If you haven't checked out the website in a while, give it a look. There are complete transcripts and resources for each episode and its corresponding segments, as well as an opportunity to receive new episodes in email, newsletter, form. We'll see you back here tomorrow, and until then, remember, one benefit of early summer was that each day we had more light to read by.